Welcome to the second set of the videos where we're going to be talking about intellectual property. And we left off the video having spoken about the various forms of intellectual property, and one other form of intellectual property that I left out was the integrated circuit designs and layouts. And this is a form of intellectual property that protects the engineering processes of putting together the components of a chip. And sometimes there is like an artistic value, or that you can say, that exists in the layout of a chip, in terms of that assists in, for instance, the performance of the chip, reduction in the materials that are used, and just increasing the processing power of that. And so some of the things that could come up as a result of the integrated circuit designs and layouts includes optimization of circuit density, placing circuits in a way that the clock and the timing signals are routed efficiently. So efficiency is another outcome that you can say is a benefit of having intellectual property in the integrated circuit designs. And an interesting thing about this is the processes that they use. And nowadays it has become so complex to the extent that in the sphere of engineering that integrated circuit designs falls in, there's a concept called photolithography. And some of the equipment that they use to make the transistors that are in the chip, to increase the number of transistors on a smaller chip and to reduce the size of the chip generally, and this is referred to as Moore's law, has gotten to a point where the cost of the equipment that's used to make that has burgeoned to the extent that it costs close to $200 million just for one of these photolithography equipment. And because they use, I think, the UV rays to do that, they become so sensitive. So copyright taking root internationally, or taking center stage, is that in the UK at that point they had really strong copyright protection, and in America, which is where Mark Twain was from, they did not. So he happened to travel to England, and he went and saw the difference between the UK and the USA. And at that point he stated something like that there were several protections for copyright in the UK, but then they lacked democracy, which was what America was known for back then. And so it was really easy for the government, or the state in the United Kingdom, to crack down on people and just abuse their civil rights, while the opposite was lacking in America. But then in America there wasn't a strong regime of intellectual property protection, and so he was like, he wished that he could trade one place for the other with regards to some of these factors, because you can't win it all. But yeah, just some of the other things that I wanted to talk about with regards to intellectual property include the idea-expression dichotomy. And so an idea is not copyrightable, but then once you put the idea on paper, which I'll refer to as the expression, then that you can that will be subject to copyright. And usually the first person to register is the one who usually gets the copyright. Another interesting, or some more interesting terminology with regards to intellectual property include the concept of novelty. And novelty refers to the need for there being a lack of previous art in the specific field, or in the specific application of intellectual property that your patent relates to. And then there's the inventive step, which is something that a skilled worker might do that somebody else who is not skilled would not be able to do. And so you can't patent an idea that's obvious to a person who's like skilled in a relevant art. So it's got to be something that somebody recognizes the inventive step that you've taken, and then there has to be a prior gap or problem that the patent is addressing. And this is now what's regarded it's what's regarded to as the inventiveness. So the prior art base is lacking in some way, and there are known issues that have not been solved, but then now your patent is the one that comes and addresses these issues. So we have other concepts like patent licenses, where the owner of a patent can allow other people to borrow or use the patents for a limited extent, but then they don't transfer the ownership of the patents. And then A patent can be compared to the trade secrets, and trade secrets are those that haven't been disclosed to people, versus the patent is in public domain, but then because you have been the first person to sort of like discover it, you can milk the patent, so to speak, for a few years. Usually there are two different or two distinct kinds of patents, and the first one is the innovative patents, which last for 8 years, and usually you just get a single claim, and the innovative patents are more referred to the the complex kind of patents that have like they're inventive, and then they've got like just some special aspect to it, especially with regards to scientific or technological field. And then there's the ordinary patents, which usually you can register, and then you can try and like upgrade or update the patents and get more than one renewal of the patent. There are things called patent examinations, and these happen where the two different concepts that you